Hello and welcome back to the Engineering Change Podcast.
But sometimes we're engineering chaos.
That's one of our guests today, Christy, Director of Government Affairs for ACEC Georgia. We'll introduce her in just a moment, but first and foremost, that's right, I said first and foremost, the answer to my security question. Joining me today and most days on the podcast, Michael Sully Sullivan.
Does that mean I can get into your bank account now? Because I know the answer.
But you don't know what the question is, so.
Oh, yeah.
Your biggest enemy.
Least favorite coworker.
My mortal nemesis.
Your grandmother's maiden name.
Sully.
What?
Grandma Sully.
And Session's back. So that means Christy Turallo's back with us. Christy Turallo, welcome.
Hi, I'm Christy Turallo.
And you've basically had all this time off since Session ended, right?
Essentially, yeah.
That's
It
what I
was
thought.
really just a walk in the park.
Has anything else happened since your last podcast
Any
appearance?
big changes, life moments, something like that?
We did walk through the park with our new baby.
New baby!
Yeah.
baby.
Yep, she's
Aw.
4.5 months old.
Baby Charlie.
She's trying to crawl, but she
Me too.
isn't trying to sleep.
I'm trying to sleep more.
She got her advancements backwards, but she'll get there.
She'll get there.
That's actually pretty consistent baby behavior.
Yeah.
I'm trying to get someplace. I'm trying to get into something. I'm not really so interested in sleeping.
Yeah.
Yeah. Well, I've been told that she will sleep before she goes to college. And she will be
Indeed
potty
she
trained
will.
before she goes to
Well,
college.
high
Indeed she
schoolers, they like to sleep a lot. They don't like to
do.
wake up early in the morning.
They
That's
do.
okay.
Yeah.
Speaking of waking up early in the morning, it's Session again. And so just
Yes.
for our new engineers out there, maybe those who just are joining the podcast, what do we mean when we say Session?
We are talking about the legislative session. So 180 House representatives and 56 senators come up to the beautiful city of Atlanta. They get under that gold dome that they just refinished. It looks a lot better. That scaffolding made it look like Pinhead, though, and it was really creepy to look at. I couldn't look at it. But they come up and they make some laws. But the only constitutional requirement for them is to, well, they have two constitutional requirements. You meet the second Monday of January. In this January, it was the 13th.
Yeah.
And then they have to pass a balanced budget.
Okay.
And that's the only thing that they have to do. But they're going to do a lot more than that.
All right.
They meet for 40 days. And just like lawmakers, it's going to take them over 3 months to get to 40 days. But they get to set their own legislative calendar. So sometimes they're off Fridays. They're off this Friday. But they come in, they gavel in, they do some administrative stuff. And then, sometimes they vote on bills. Not yet, though. They're still doing stuff like hearing the state of the state, where the governor comes in and does a joint session where all the lawmakers get to hear what his priorities are. And his floor leaders will be carrying those bills. He talks about what his budget priorities are. And then there's a state of judiciary where like the chief justices come up and they're all in their garbs, and it's really cool to see. I recently learned that there are 7 rural counties with no licensed attorneys.
Oh, wow.
Yeah, so there are legal deserts. 30,000 individuals have no access to legal counseling.
That's horrible to hear.
Yeah.
It's like one of our fundamental rights.
Yeah.
Okay, back to Session. Sorry.
It
I just thought that was very interesting.
Yeah.
So we'll do crossover.
Okay.
Legislation is introduced in one house or the other, one chamber or the other. By Legislative Day 28, that's crossover day this year, you have to get your bill out of the chamber of origin and get it to the other side. So that's a really long day. I think last year didn't leave until like 12:30, and I was pregnant, and it was crappy because those floors are really hard.
Right.
And I was really sick.
Those floors are hard for the best of us.
Yeah.
It is the hardest surface on earth, the marble at the Capitol.
Yeah, and I was still wearing heels. I was really trying to fight it out.
I mean, to be fair, Sully's wearing heels most of the time, too.
Yeah, well, he can pull them off.
The way they accentuate my calves. Yeah.
And then there's the second longest day, which is Sine Die, though. Last year, it was the longest day. I didn't leave until 2 a.m.
Wow.
And that'll be set for April 4th. right before the Masters. So
Wow.
they'll all
Total coincidence.
Total
they'll all get
coincidence.
to go home and watch golf and do very quiet things,
Quiet clapping.
for a week. So
So we at ACEC Georgia, we obviously have some interest in bills being passed from year to year. Sully, why don't you give us a broad overview of what we're watching this year before we get into the details?
Well, to start by saying we do have some things that we're watching, some things that we're actually introducing on behalf of the engineering industry. But that's part of what we do at the Capitol. The other part of what we do at the Capitol is watch to see pieces of legislation that other people introduce that either we might want to support because it's a good idea, or what is more often the case, we might want to work against because it's a really bad idea. Or maybe a good idea that they haven't thought about the unintended consequences of that good idea. So that's what we do down at the Capitol. This year, our number one legislative priority is a bill to take Georgia's existing Mini Brooks Act. The Brooks Act is the federal law that requires qualifications-based selection to be the process used to procure design professional
I've been
services.
telling people it's all about small creeks. I'm so sorry. Mini Brooks.
Mini Brooks. Yeah, well, it's a different Brook.
Okay.
It's a different Brook. Representative Brooks, who was a congressman from Texas,
Huh.
who introduced and led to the passage of the Brooks Act in 1972. Those of you that go to engineer trivia, there's the answer to one of those questions. I don't know if that's a thing, engineer trivia or not.
It's got to be.
It should be.
he named it after himself.
Yeah, that's interesting, right? Like,
They usually don't name them after themselves.
no, I was actually trying to think. Well, you got Smoot Harley, Antitrust
Monopoly.
Act. You've got there's some things. Pell Grants were named after Senator Pell from Florida. Yeah, there's some other ones that I don't think they actually name it after themselves. I think like
Somebody.
it's an
okay.
honorific
All right.
that they call it by the name of the champion of the bill. So yeah, 1972 in Congress passed the Brooks Act that requires that engineers, architects, other design professionals be selected on any project that has federal dollars involved. So it doesn't have to be the federal government actually doing the project. If the federal government gives money to the state, Brooks Act applies. If the federal government gives money to the state that the states give to local governments, or that goes directly to local governments, the Brooks Act applies. So that's been the law of the land for almost 60 years. And that is the law in 46 of the 50 states at the state level.
Okay.
That's what's called a Mini Brooks Act. There's the Brooks Act, and then there's the Mini Brooks Act. So all but 4 states in the union require that at the state level for state agencies. That's been the law in Georgia since Ronald Reagan was president in the early 80s. And then 28 of the 50 states also require that at the local government level for cities and counties. And if you look at the 13 states that are generally considered the South, 10 of the 13 states in the South also require it at the local government level, including 4 of the 5 states that neighbor Georgia. So what we're proposing isn't really something new, but it's something that's very important, because using cost as a component or the sole component of procuring design professional services is literally the worst way that you can do that. And we'd like to see that expanded at the local government level. We've been working on it a long time, and we're hopeful that we'll get it passed this year. The other bill that we're introducing is a bill to, it's a much shorter bill, I should say. It's a bill that will decouple the requirement of experience to get one's professional engineering license from taking the test. Right now, you can't take the test in Georgia, the PE exam, until you get your 4 years of experience. At one point, that made sense because the test was really an experiential test. It was testing your practice, but that hasn't been the case for many years. It's really more of a knowledge test. So it would be more appropriate to maybe take that test closer to one's educational experience and then get your experience. So we're not changing the requirements of what it takes to become a licensed professional engineer. We're just saying you can do these 2 things. They don't have to, one does not have to follow the other. I was joking about the length of the bill because literally all we have to do to make this law is delete the word subsequently from the places that it occurs. And then we have to cap it. It says subsequently pass So we delete all the subsequently's and we capitalized all the passes. It's very complex stuff that we do to the capital.
Really excited about that one.
Yeah, so those are the things we're introducing. And then, Christy, do you want to talk about some of the other things that we're following, kind of consistent with the fact that we represent the business of engineering? So some of the things we do are engineering, like engineer licensure, and some of the things we do are business. Things that affect not just engineering firms, but all kinds of businesses.
Well, business is good down there. And we are following two big legislative initiatives. We talked about this a lot last year. We are following tort reform. And the governor has come out full force for tort reform, though we don't know exactly what the details of his legislative
Now,
package
for
are gonna
people
be.
who, again, maybe aren't familiar with the lingo, what is tort? What is tort reform?
What's a tort? So tort reform is really just kind of a broad phrase that we use to talk about the state of Georgia's courts
Okay.
as far as like plaintiffs are concerned. So we have a lot of plaintiffs' attorneys in the state of Georgia who, sometimes can really get some good verdicts for their
Yeah,
clients.
I hear about that all the time on the radio.
Yep. I mean, they strong arm them, that's for sure.
Strong arm of the law.
Um,
Your
so-
bald attorney. That's another one that I like.
yeah, my
Yeah.
bald
My
attorney,
bald attorney.
my 25% attorney.
My
Yeah.
25% attorney, yeah.
The
Yeah.
CEO lawyer.
Oh, I haven't
there's a
seen that
CEO
one.
Yeah.
lawyer.
Okay.
I don't know what makes him that, but yeah, he's a CEO lawyer.
And then, of course, there's good old Morgan and Morgan.
Morgan and Morgan.
Oh, so many
And Morgan
Morgans.
and Morgan and Morgan and
Oh
Morgan.
my God. Okay. So, as a lot of people are aware, your insurance premiums have probably gone up.
Yeah.
I don't really use my car insurance very much. I got it towed once because I've added that to my insurance because I don't know how to work on cars.
Makes sense.
But my insurance has gone up
Mhm.
personally, and I've never like gotten into an accident. Knock on wood. But insurance premiums across the state are going up
Mhm.
because of these nuclear verdicts, and because people can sue. And they know that some of these businesses know that they need to settle outside of court because they don't want to have a nuclear verdict. And what a nuclear verdict is really just a settlement on behalf of the plaintiff. That's huge.
Mhm.
Like $37 million or however many $1 million it was to the individual who was shot in the Kroger parking lot. And Kroger had to pay for this man's the settlement after he was shot by someone who was not affiliated with Kroger.
Right.
Someone was trying to rob him. Six Flags, this deals with premises liability. An individual was at a bus stop outside of Six Flags parking lot or property, and he got jumped. And Six Flags had to pay millions and millions of dollars.
It wasn't even on their property.
Nope. But they said because the individual started following this man on Six Flags' property, even though Six Flags had no idea,
Right.
they were liable.
Yeah.
So we're seeing lots of these nuclear verdicts in the state of Georgia. There was the Ford rollover case, which was the largest punitive damages verdict in the state of Georgia, and that was huge. And that dealt with a lot of different things, like the seatbelt gag order, which is like a really arcane thing where even though you have to, by law, wear a seatbelt, you can get a ticket for not
Mhm.
wearing a seatbelt. If you get into an accident with someone who's not wearing a seatbelt and they suffer injuries and they're like, it was your fault that this accident happened and then I was thrown from this windshield, you don't get to say, well, you probably wouldn't have gotten thrown from the windshield if you were wearing your seatbelt. You
Mhm.
cannot,
It's not admissible.
admissible. You cannot enter that evidence into court.
And why that's important is Georgia did do tort reform. It's kind of like you do it and then you have to redo it because it gets whittled away over time. But back in 2005, we did do tort reform, and we created a rubric where in a tort case, there's a apportionment of damages,
Mhm.
right? How much liable are you? What percentage liable are you? So in that Ford rollover case, if you were able to introduce evidence relating to the fact that a big part of why the injuries were so catastrophic was because the plaintiff was somewhat liable for their actions. that would have potentially reduced the verdict, although probably not, because the Kroger case, this is my favorite fact about the Kroger case that Christy mentioned. So again, Kroger did not shoot the person.
Mhm.
Kroger was not aware of any beef going on in their parking lot. The person who shot the individual who committed the crime on Kroger property and shot the other person, what their percentage of negligence was found to be, or percentage of liability was found to be like 5%.
Yeah, something in the single digits.
And
even though-
Kroger, who again did not fire the gun,
Right.
no Kroger employees were involved, were found to be 95% liable.
Oh my gosh.
And that's a reflection of why we why we are ranked the #1 judicial hellhole.
Mhm.
That's judicialhellholes.com. Yes, that's a real website. We're #1.
Or is it judicialhellholes.org?
Maybe .org.
Just Google it. You
Just
can find it.
Google judicial hellholes. Don't juggle.
No, don't juggle
Particularly
the
when you're
judicial
driving. While you're
hellholes.
driving, that would be
Yeah.
bad. Is because here they had to do that insane apportionment of damages to get to the deep pocket to say, oh,
Mhm.
well, they're 95% liable, so giant verdict.
Now, with all this, I think I remember you guys talking about this last year. The state gets a portion of the.
Yes. For
Yeah.
punitive damages and product liability cases,
Okay.
the state actually wins.
Okay.
They get a large portion of the verdict.
So, with a motivation like that to change the law, what's the likelihood of tort reform passing this year?
So fortunately, the legislators aren't the ones that are personally,
They don't get a cut.
yeah, they're not personally benefiting from it. So when we say the state, we are talking about like the bureaucratic arms
Right.
of the state. But we're seeing the insurance commissioner, John King, come out in full force. I mean, he went to committee last year and testified in support of tort reform initiatives. That's strong.
Mm-hmm.
And he has, some direct skin in the game. He is the insurance commissioner, and their job is to help Georgian citizens with their insurance.
Mm-hmm.
So, like, there are the powers that be are coming around to it, and we're really excited to see that kind of stuff. We just don't know what kind of provisions that we're looking at.
Yeah, I mean,
just yet.
Commissioner King's case was, you don't have to be sued for your insurance to go up. Your
Right.
insurance is going up because the cost, these nuclear verdicts are increasing the cost of this. And it's not just insurance companies being forced to raise their rates to stay in business. Now we're in the situation where we have insurance companies, as happened in Florida, looking at leaving the state because they do not want to operate in this environment. Fewer insurance companies, reduced competition, accelerates those rates, and that was why the commissioner got involved. Fortunately, we have an example to follow, which is Florida, who, as they saw that happening, they passed tort reform, which is pretty incredible. If you've ever driven through Florida, you think we've got a lot of lawyer billboards.
Yeah.
They've got a lot of lawyer billboards, and it was a huge industry there and a very powerful lobby that they had to legislators had to go up against. So we've got a game plan and a good example to the South to look to. And fortunately, unlike last year when we were talking about tort reform, the governor has indicated that he is going to throw his full weight into this effort, including threatening. I think it's called threatening. He told the General Assembly that they needed to pass tort reform, that it was his number one priority. And if they didn't pass tort reform in this legislative session, that he would call them back into special session for the sole purpose of passing tort reform. So that hopefully will change the vote count, because was it 2 years ago that we tried to do premises liability, and the Senate was like 3 votes shy, I want to say.
Yeah.
So it's close.
Right.
And hopefully the governor can be the difference maker in that.
Yep. On the other initiative that we're working on, other than tort reform, that the business community is really behind, is an Open Records Act fix. So back in August, or summer, August. An individual that works for the University of Georgia Tech University.
Georgia Institute of Technology.
I'm not sleeping, guys. I have a form. I want to go home. Georgia Tech University. He was a professor, and he was also a contractor.
Mhm.
He was a full-time employee of Georgia Tech, but also a contractor. He was served with an open records request, and Georgia Tech was served with this open records request. Georgia Tech responded. He did not respond because, like, that's just not how open records kind of works.
Mhm.
You know, you talk to the agency that is the custodian of the record in which
Mhm.
you're trying to get.
Right.
And he was sued for not responding and for not
Not responding in a timely
forthcoming.
manner. And there are significant financial penalties to
Oh,
a,
wow.
like a state agency or a local government that does not
Mhm.
respond. There are penalties attached to that non-responsiveness if they don't respond within the required period of time.
So he's not forthcoming with these documents because he was like, I'm a contractor.
Right.
I'm not the custodian of this record that this man is seeking. And he got sued. And Fulton County Superior Court, they were in favor of him. Then it went to the Court of Appeals. They were also in his favor, the professor's favor. And then he went to the Supreme Court.
Mhm.
And they were like, actually, you are a custodian of the public record because you are an extension. Even though you're a contractor, you are an extension of Georgia Tech, which is a public university. You have to be forthcoming with these public records when you are asked to furnish one. And you have 3 business days, by the way,
Oh,
to
wow.
furnish
As an
an open records.
individual.
Right.
Wow.
So the consequence of this Supreme Court ruling is that
Georgia Supreme Court.
yes,
Mhm.
Georgia Supreme Court is that contractors who do business with any political subdivision of this state, that's a local government, that's a
Mhm.
school board,
CID.
that's a CID, that's the commissioner of insurance. If you are doing any kind of work on behalf of any person, any state agency or entity, you now are on the hook for
Yeah.
furnishing public records.
Mhm.
And if you don't within 3 days, you can get fined $1,000.
Oh, wow.
Yeah. Um,
So we're hoping to fix that.
we are hoping to clarify
Okay.
that contractors or like a consulting engineer.
Yeah, when we say
Working.
contractors, we don't mean AEC, the C and AEC. We mean
Yeah.
any entity that is contracting with the
Right.
state.
Yes.
It could be a service provider. It could
A
be
vendor.
somebody selling the state pencils. Any entity that it has a contract to provide a good or service to the state is a contractor when we're talking about contractor in
Wow.
this context.
Yep. Even if you're just an individual, as long as you got a contract with the state, you are now on the hook for these open records, and you can be sued or
Mhm.
found guilty and charged
Oh, wow.
with these fines. The first charge is $1,000. Any subsequent charge is $2,500. And if you are taken to court, the complainant,
Complainant.
complainant, they can get attorney's fees from you too.
Oh, wow.
Mhm.
Wow.
So in this case, it was like something like $50,000 that the professor had to pay
Oh
in
my
attorney's
God.
fees. Yeah. So, I mean, it's not just like I'm a guy selling pencils
Mhm.
to David A. Purdue Elementary School in Warner Robins.
Mhm.
I'm a guy that now needs to know the Open Records Act.
Right.
And how many days I have to furnish these records, or to at least acknowledge and say, okay, these are, I know that this record exists.
Mhm.
Here's a description of the record, and this is when you can get it. If you have to pay, because entities can charge for
Mhm.
these types of records, there are limitations on what you can charge the individual in order to get the record. So there's a lot that goes on, and knowing the
Mhm.
nitty gritty of that law is incredibly burdensome
Yeah.
for any individual, even attorneys.
Yeah.
Like, not all attorneys know open records requests.
Right.
So, like, you have to know the law now and you have to be able to furnish
Wow.
because of the Supreme Court ruling. So, what this bill would do, it's SB 12, Senate Bill 12 by Senator Frank Ginn, um, and many, many, many others. He got a lot of co sponsors on this. It clarifies that if you are a contractor or doing business with the state, that you are not the custodian of the record. You are not going to be held liable to furnish the record.
It really
Right.
just really reestablishes the status quo as everyone universally, including to Christy's point, Fulton County Superior Court judge and the judges of the Court of Appeals. Everyone has always understood that the way it works is that the open request is made to the political subdivision, the state agency, the local government, and they have, because as you can imagine, local governments are receiving open records requests, some of
Right.
them every day, sometimes multiple requests a day. There's a designated person who understands the Open Records Act, understands importantly what the exceptions to the Open Records Act are, and it's their job to respond to those kinds of requests. It's a universally understood status quo that the Supreme Court decision overturned. So when you think about the unintended consequences, of course, the Supreme Court doesn't have to think about unintended consequences; they
Right.
just decide cases, right? And they interpreted the law very broadly. The reason that it changed was kind of the understanding was that this would apply in those instances where a contractor were standing in the shoes
Mm-hmm.
of the government. So in an example, like a lot of the Fulton County cities and DeKalb County cities, newly created cities, they hired engineering firms.
Right.
So the planning director of the city
It's
was an
contractor.
engineering firm employee, right? So they're standing in the shoes of the
Mhm.
government. That kind of is a different scenario than the guy who's just selling pencils to the school
Right.
board. And before any of our, this may not be the most exciting thing. Maybe we file this under boring but important. I've already gotten a member firm that has reached out who has received an open records request.
Oh, wow.
This isn't theoretical. This just came out in August, and I've already had one member that's reached
Wow.
out to us about how to navigate that response. And the answer is that's the law right now unless
You
hopefully
have
Senate
to
Bill
provide it.
12 passes. Right now, you have to provide it.
Wow.
You can also think of, so again, that there's consequences of that, right? That person in an engineering firm doesn't know how the Open Records Act works. So you got two problems, right? You could have somebody requesting in sort of a malicious way,
Mhm.
I didn't win the contract, you won the contract. Now I'm
Mhm.
going to wear you out with a bunch of document requests, and you've
Right.
got some administrative assistant who doesn't even understand how the Open Records Act works, and they're trying to be responsive, and they could give that person, that other company, information that is actually not required to be given under the Open Records Act, things like trade secrets or information from which they could derive the competitive advantage that your firm used that got you to win that contract.
Mhm.
They could inadvertently give information out that they're legally not required to do, even under this broad definition
Wow.
that the Supreme Court decision stands for. So,
Wow.
yeah, it could
It's a
be
big
really bad.
deal.
It's a big deal. It's very
Yeah.
important.
Sounds like it.
Yeah.
Sounds like it.
And again, not theoretical. At least one firm in Georgia has already been served. So
Are we watching anything else business related, or do we want to turn to a little more in depth on QBS?
We're interested in seeing if cornbread becomes the official bread of the state of Georgia.
I am too, and I want it to be pure cornbread, no gluten, please.
I don't know, man. I'm
Oh my
kind of a
gosh,
biscuit
you
girl.
gluten people.
you're in favor of biscuits?
Yeah, I'm a biscuit girl.
I would just say cornbread, no sugar.
I'm
Those are
I'm
corn
okay with
muffins.
that.
Those are not cornbread. It's
Yeah.
Georgia. No
Mm.
sugar in your
Yeah.
cornbread. Only in your tea.
The
Lots of it.
sugar to my cornbread.
That's for next episode.
Yep.
That is, by the way, that's a real piece of legislation that has been introduced. Those legislators do like to have fun from time to time. Loyal readers of Christie's Capital Update will remember a few years ago when there was an effort to make the possum the official marsupial of the state of
Oh,
Georgia.
did that fail?
It did.
Poor possums.
Well, it didn't fail. It just never passed. There's a difference between not passing and failing. But I heard that the bill just didn't have the necessary qualifications.
Dum-dum-ts.
That was the koala lobby's
Yeah.
argument. They wanted to be the official marsupial. They didn't really have a strong claim. We're not really known for our koalas in Georgia. Whereas
No,
we are known for our possums.
we are.
But yeah, that's it on the business side, I think.
For now, things change.
Yeah,
Things change
definitely.
and
Well,
evolve.
it's the 88th. Oh, it's the 8th legislative day, not 88.
Feels like it.
It feels like 88.
Feels like the 80th day of January.
Yeah,
It does feel like the 80th day of January.
January 88th. Well, we do have a couple of asks relating to QBS.
Yes, sir.
For those folks who are still paying attention to this podcast and haven't switched to something else. One is if you're personally aware of an instance where a local government entity used low bid to procure professional design services and bad things happened, whether it be horror stories, you might say. So it could be something catastrophic, hopefully not. But if you know about one, let us know about that. But even stuff like, massive schedule delays, massive change orders, things that resulted in a much higher cost for that project because of the low bid professional design services. Let us know about those. Christy and I, our emails and our cell phone numbers are on our website, acecga.org. Send us an email with that story and that information. If you don't want to tell us the jurisdiction because they're your client or they regulate a lot of your clients, that's fine. You can leave you just kind of give us a direction, like a county in North Georgia or a county in Southwest Georgia. Keep it non-specific if you want to, but if you don't want to, go ahead and rat them out. Let us know who they are. So that would be hugely helpful on sort of the, I guess we'd say, negative information side. And then on the positive information side, if you're aware of a local government, local government, primarily counties, the posture that we're in, we've been working with the Georgia Municipal Association, which represents all the cities in Georgia, as well as the Association of County Commissioners of Georgia, ACCG, that represents the counties. The Municipal Association is in an officially neutral position. They're not opposing the bill. The Counties Association, they haven't taken a formal position yet on the draft that we have that was introduced yesterday in the House and the Senate, but we're assuming that they will again oppose the legislation. So counties that you're aware of that use QBS, even in those instances where they're not required to by law, because they think and understand that it is the right thing to do, it will lead to the best outcomes for them. If you can identify those counties that are using QBS, that are sort of champions of QBS, and if there are specific officials within those county governments that might be willing to help in our efforts to communicate that they are supportive of this legislation and they think it's the right thing to do, that would be hugely helpful to us. And thank you to those of you who may be listening or watching on YouTube who've already done that. We've actually had some great conversations with some county officials who are supportive of the legislation and actually intend to engage directly in that support with their association. So if you know of those county champions of QBS, let us know that too. That'd be great information.
Very good. Well, I think that brings us to a close for our first episode back during the session.
We did it.
We did it.
Oh
Yay us.
It's already over.
It's already over.
That wasn't so painful.
It wasn't so painful.
Well, maybe it was for you guys.
We found it fascinating.
Absolutely. Good stuff.
Exhilarating. Hey guys, thanks for joining us once again. We look forward to having another episode to you very soon as things continue to change and evolve this legislative session. As always, thanks for watching, and we'll catch you next time.
And continue to engineer that chaos.
For ACEC Georgia, I'm Brett.
I'm Sully.
I'm Christy.
We'll see you next time.
Intro and closing music. Intention by the Down and Outs. Music used with permission. Engineering Change is a production of ACEC Georgia. Copyright 2024, all rights reserved.